Ready? Exercise number 15, Series B, Legal Matter. Start. When the High Court says that there shall be no coercive steps, this would also mean that you cannot be interrogated. This hampers investigation. The right to investigate is with the IO, not with the court. The discretion of arrest lies with the IO and not with the court. The court can exercise this power in anticipatory bail and bail pleas. But let's not say that the court will decide how the investigation is done or that the court can pre-injunct the rights of the IO. It is in your the accused interest also that the investigation is done. Stop. Next para. Upon the registration of the FIR, the accused is mainly worried about the arrest. So 438 is the remedy. If the FIR is investigated and no case is made out, then the police gives ABC summary report and it will be considered. It is in the interest of the accused also that the investigation is carried out. Nowadays, within 1 day of the lodging of FIR, the quashing is short. There is no time given to the IO. Stop. Next para. Is the High Court justified in passing an order when there is an alternative remedy under Section 438 of the CRPC which has been invoked? What way you will be in two courts? Stop. Next para. If the counsel prays for pre-arrest bail, then he may be asked to specify if he has moved a 438 application before the Sessions Court. In that case, he must be asked to go there or withdraw the same. One cannot be given multiple chances. Normally, when counsel find that the court is not inclined under 482, they withdraw it and go under 438. The client may also engage another counsel to go under 438 and counsel that fact. As judicial officers, we tend to put sections and jurisdiction in parts. It leads to complications at times. Just now, we were hearing the matter for alienation of property in public trust. Otherwise, there is no fear of the law, of the consequences, whether it is civil or criminal jurisdiction. Stop. Next para. In the instant case, the petitioner had impugned an order of the Bombay High Court allowing another bidder to complete the formalities and procedure for the sale of the property of the public trust. On the repeated failure of the petitioner to deposit the requisite sum with the registry of the court and finally on his check being dishonored. Stop. Next para. The rising trend among high courts across the country to routinely grant interim relief by way of a stay on any coercive action pending a writ petition or a plea under Section 482 CRPC for quashing of criminal proceedings. Accordingly, the bench undertook to lay down guidelines in this behalf. Stop. Next para. The bench was hearing an SLP arising out of a September 2020 order of the Bombay High Court on a writ petition. While granting time for the filing of a reply affidavit with additional documents. The High Court had in the interim directed that no coercive measures be adopted against the present respondents under bracket director of a real estate development company and his business partners bracket out in this respect of the FIR registered by the present petition under bracket Niharika Infrastructure Private Limited bracket out with the economic offences wing for alleged offences under sections 406, 420, 465, 468, 471 and 120B of the IPC. Full stop. Thank you very much.